Morning Grandpa scheduled the will review. I stood in my kitchen with my purse open on the counter and my hand deep inside it, moving things aside one by one as if the bottle might have slid into a seam. Keys, wallet, a folded receipt from the grocery store, a packet of tissues, a phone charger I never remembered to take out. The prescription bottle wasn't there. I checked the side pocket, then the zip compartment, then the small interior slot where I kept my insurance card. I turned the purse over and shook it gently, listening for the plastic rattle that should have been immediate. Nothing. My lower back was already tightening the way it did when I'd been on my feet too long. It wasn't dramatic pain. It was the steady mechanical kind that made ordinary movements cost more than they should. Standing at the counter, I shifted my weight from one leg to the other, trying to buy time. Grandpa's living room was a few blocks away. I could make it there. I could sit down. I could keep my face neutral. But the review wasn't going to be a quick hello and a handshake. It was going to be paperwork on a coffee table, questions I couldn't predict, and the expectation that everyone in the room would be paying attention. I needed the medication to be able to stay upright in that chair without shaking. That was the risk, plain and simple. Not embarrassment, not discomfort. Whether I could physically hold myself together long enough to be taken seriously. I told myself not to spiral. I was 32 years old. I lived alone. I paid my own rent. I filed my taxes early every year because I hated surprises. My life was built around managing what my body did on its worst days. I didn't misplace things like this. I set the purse down and went through my routine like I always did when something felt off. I retraced the last 24 hours in order, not in panic, but like balancing a checkbook. Yesterday afternoon, I'd stopped at the pharmacy on Ogden Avenue. I remembered it clearly because the line had been long, and I'd leaned my hip against the counter to keep pressure off my spine. The pharmacist had slid the bag across to me, stapled shut, my name printed on the label in black ink. I'd signed with the pen attached to a chain. I'd put the bag straight into my purse because I didn't want it visible on the passenger seat. Then I'd driven to Grandpa's house for dinner. I had arrived early to help set the table the same way I always did when Melissa was involved. It was easier to be useful than to be noticed. Grandpa had been in his recliner by the window with a blanket over his knees, watching the Weather Channel with the volume low. He looked smaller than he used to, but his eyes still tracked everything. Morning meeting, he'd said, as if he were confirming a work appointment instead of a family one. I'd nodded. Karen's coming by at 10. He'd grunted like that was satisfactory and turned his attention back to the screen. Melissa arrived later, dressed like she was going to church, hair pinned neatly, nails done. She kissed Grandpa's cheek and let her hand linger on his shoulder in a way that looked affectionate from the outside and possessive if you were close enough to understand her timing. She barely looked at me. That was normal. Melissa didn't waste energy on things she already considered settled. We ate dinner. Grandpa didn't say much. He asked me about my work once, a simple question about whether I was still doing numbers for those small businesses. I said yes. Melissa talked about how busy she'd been helping Grandpa with forms and appointments, as if his life were a project she managed. Afterward, I'd wash dishes while she sat at the table with her phone out, scrolling and smiling at nothing. I remembered seeing my purse on the chair beside the counter, where I always kept it close enough that I didn't have to bend down and lift it more than necessary. At some point, I'd gone to the bathroom and left my purse in the kitchen. That was the part that didn't sit right with me now, because I did not leave my medication unattended. Not in someone else's house, not with someone like Melissa moving around. I leaned against the counter and pressed my fingertips into the edge of it until the coolness steadied me. I told myself to check the car. People forget bags in cars all the time. I grabbed my coat and moved carefully down the steps, one hand on the railing, taking them one at a time. Outside, the air had that late fall sharpness that made everything feel more exposed. My car was parked along the curb in front of my building. I opened the passenger door and looked at the seat, the floorboard, the center console. No pharmacy bag, no bottle. I climbed into the driver's seat and sat there for a moment with my hands resting on the steering wheel. The quiet inside the car was different from the quiet in my kitchen. It didn't feel like calm. It felt like a pause before something that had already started. My phone buzzed in my coat pocket. A calendar reminder, will review 10 a.m. I looked at the time, 8:42. I could still drive to the pharmacy and ask them to reprint the label, confirm the pickup, tell me exactly what time I'd signed. I could do that without accusing anyone. It would be information, not a confrontation. But the meeting was at 10, and Grandpa didn't like delays. Neither did Karen the attorney. If I showed up late, flustered, walking stiffly, it wouldn't matter what I said afterward. The room would already have decided what it wanted to believe. That was what I couldn't ignore. The missing bottle wasn't just a missing bottle. It was a lever, a way to make me look unreliable at the exact moment reliability mattered. I started the engine anyway and pulled away from the curb, telling myself I wasn't going to jump to conclusions. I wasn't going to do what Melissa would do, pick a story and force everything to fit inside it. I was going to find out what was true, and I was going to do it before I walked into Grandpa's living room without the one thing that kept my hands steady. By the time I turned onto Grandpa's street, the stiffness in my back had settled into something heavier, less forgiving. It was a clear October Thursday, the kind of morning that made the lawns look orderly and harmless. Nothing about the neighborhood suggested that anything was off. Melissa's SUV was already in the driveway. Karen Doyle's sedan was parked at the curb, a slim leather briefcase visible on the passenger seat. 10 o'clock meant 10 o'clock to her. She handled estate planning for families who expected order. I wiped my palms on my coat before stepping out of the car. Grandpa's front door was unlocked. It usually was when he knew someone was coming. I moved carefully down the short hallway into the living room. They had already arranged the space. Grandpa sat in his recliner near the window, a small folding table set up beside him. A neat stack of documents rested on it, clipped and tabbed. Karen sat upright on the sofa, reading glasses low on her nose, a legal pad balanced on her knee. Melissa stood behind Grandpa's chair, one hand resting lightly on the back as if she were anchoring him there. 3 heads turned when I entered. I lowered myself into the armchair across from Grandpa and adjusted my posture so the strain didn't show. The absence of the medication was not theoretical anymore. My hands felt unsteady. I kept them folded in my lap. Karen began by reviewing the purpose of the meeting in measured professional language. Grandpa had requested a formal review of his current will and any potential amendments. She outlined the structure of the documents, the role of the executor, the distribution percentages. It was orderly, predictable. Then Melissa shifted the tone. She didn't interrupt. She waited until Karen finished describing the section on fiduciary responsibility. Then she leaned slightly forward and redirected the room without raising her voice. She told them I had been struggling again, that I had a pattern of mismanaging my medication when stress increased, that it wasn't about blame but about prudence. She said the family had been through this before. She implied that oversight might be necessary. She never looked at me directly. What she did look at was Grandpa's face. The shift was subtle but visible. His brow tightened not in anger but in concern. Concern was worse. Concern invited protection. Protection invited control. Karen's pen paused over her notepad. No one asked me for clarification at first. The accusation settled into the room like it had been rehearsed. I felt the familiar narrowing that happened when a story about me was being told in my presence, but not by me. The risk was no longer about whether I could sit upright without shaking. It was about whether I would be recorded in the notes of an estate attorney as unreliable. Melissa added details that sounded responsible on the surface. She referenced my back condition, the prescriptions, the need for stability when managing financial matters. She framed it as safeguarding Grandpa's wishes, not attacking me. That framing mattered, because this wasn't a family argument. It was a formal review. Anything said here could influence how assets were structured, who was trusted with authority, and who was not. Grandpa shifted in his chair and looked at me, not accusing, not dismissive, but evaluating. I understood in that moment what Melissa was doing. If Grandpa altered the will today, if he adjusted percentages or designated roles, it would be difficult to untangle later. It wouldn't require proof. It would require only doubt. And doubt was easier to plant than evidence. Karen cleared her throat and asked if there were any specific incidents she should be aware of. Melissa supplied a general timeline. She avoided dates. She avoided specifics that could be verified. She spoke in impressions and patterns. I felt heat rise in my face, not from shame, but from the effort of remaining still. The absence of the bottle in my purse that morning now had weight beyond inconvenience. If I appeared unsteady, if I asked for a break, if I shifted too often in my seat, each small movement could confirm the narrative being constructed. I became conscious of every breath. Grandpa rested both hands on the arms of his chair and leaned back slightly. He did not agree. He did not dismiss her either. He asked one question, measured and direct: how often I had been filling my prescription lately. The room went quiet again. Melissa's hand tightened fractionally on the back of his chair. Karen looked from him to me. It was a simple question, but it carried the authority of the person whose signature controlled everything on that table. I answered with the schedule written on the label: every 30 days, no early refills, no adjustments outside what my physician prescribed. Saying it aloud felt thin against the implication that had already been introduced. The review did not stop. Karen continued outlining options, but the tone had shifted. Where there had been clarity, there was now an undercurrent of evaluation. When the meeting concluded for the morning, no changes were signed. Karen gathered her papers with professional calm and said she would follow up after clarifying a few matters. Melissa walked her to the door. I remained seated for a moment after they left the room, letting the pain settle into something manageable before standing. Grandpa looked at me again, longer this time. He did not accuse me. He did not reassure me either. The uncertainty was the most dangerous part. As I rose carefully from the chair, I understood that the missing bottle had not just been a personal inconvenience. It had arrived at the exact hour it could reshape how I was seen. And in matters of inheritance, how you are seen can determine what you are allowed to keep. Karen did not leave immediately after Melissa walked her to the door. I was still in the hallway when I heard the soft murmur of her voice return toward the living room. By the time I stepped back in, she had set her briefcase on the coffee table again and was looking at Grandpa with the same measured expression she used when explaining tax implications. Melissa stood near the doorway, arms folded, now less composed than she had been 10 minutes earlier. Grandpa did not raise his voice. He did not repeat the accusation. He asked a narrower question. If there was concern about how often I was filling my prescription, was there a way to verify it instead of speculating? Karen adjusted her glasses and nodded. Yes, she said in practical terms, but only with my written authorization. Without it, the pharmacy could not release any information. With it, they could confirm pickup dates and refill intervals. Nothing beyond that. The shift was small but concrete. The room moved from implication to procedure. Melissa responded carefully. She said verification was fine. Transparency would be good for everyone. She framed it as protection again. I understood the risk immediately. If I hesitated, it would look like guilt. If I agreed and something was unclear in the records, even for a technical reason, that ambiguity could settle into Grandpa's mind in ways I couldn't undo. I did not hesitate. I told Karen I would sign whatever release was necessary. She retrieved a standard HIPAA authorization form from her folder, already blank, except for my name typed at the top from prior estate documents. The form specified the pharmacy by name and address. It limited disclosure to prescription fill dates and refill history for the past 12 months. No diagnoses, no physician notes, no broader medical file. That detail mattered. It meant the review would stay focused. I read the form carefully. I checked the date. It was October 12th, a regular business day. The pharmacy would be open. If Karen faxed or emailed the authorization before closing, there was a chance they could confirm by the next day. I signed on the line, indicated, and dated it. Karen countersigned as the authorized recipient and placed the document in a separate section of her file. Melissa's expression shifted again just briefly. Not alarm, calculation. Grandpa watched the entire exchange without interruption. He did not look at me with suspicion anymore. He looked at the paper. That was the first moment I understood how much paper mattered in this house. Forms, signatures, tabs, everything written and clipped. The conversation did not continue in circles. Karen outlined the next steps plainly. She would contact the pharmacy that afternoon. If they required additional verification, she would provide it. She would not advise Grandpa to execute any amendments until the information was reviewed. That last part landed differently. Execute any amendments. It made the stakes visible. The documents on the folding table were not theoretical drafts. They were prepared for signature. Melissa stepped closer to Grandpa's chair again, but she did not object. Objecting to verification would have been obvious. Instead, she pivoted. She said she only wanted to ensure Grandpa wasn't placed in a position where someone unstable might influence him. She said she had seen what stress did to me. It was subtle. The accusation shifted from medication misuse to overall reliability. Karen made a brief note on her pad. Not about instability, about pending verification. The distinction was thin but important. I felt the fatigue settling into my lower back, a reminder that my body was still part of this equation, whether I liked it or not. I adjusted in the chair, careful not to grimace. Grandpa finally spoke in a way that ended the morning. He said he preferred facts, not impressions. He instructed Karen to proceed with the verification and to reschedule the review for early the following week if necessary. He would not sign anything that day. Melissa's jaw tightened before she caught herself. No signatures meant no immediate change. No immediate change meant time. Time meant records. When Karen gathered her things again this time, she left. Melissa stayed. The room felt smaller without the attorney there to anchor it in structure. Melissa turned toward me, but she did not repeat her claims. She studied me in a way that suggested she was measuring what had just happened, not reacting to it. I realized then that the missing bottle that morning had not only been about how I would look in that chair, it had been about timing. If Grandpa had signed amendments before the question was raised, the release form would not matter nearly as much. Now it did. I stood carefully and said I would wait to hear from Karen once the pharmacy responded. I did not accuse Melissa of anything. I did not ask about the dinner, the purse, the kitchen. There was no proof yet. Only a form with my signature and the understanding that within a business day or two there would be a record. And records, unlike impressions, do not shift, depending on who is standing behind the chair. Karen called me the next afternoon just before 4. I was at my apartment in Naperville, sitting at the small dining table with my laptop open but unread emails on the screen. I had worked remotely that day, answering client messages in between stretches on the living room floor to keep my back from tightening completely. Her voice was steady, the same tone she had used in Grandpa's house. She had received confirmation from the pharmacy. She summarized first: no early refills, no overlapping prescriptions, every pickup spaced at 30-day intervals consistent with the dosage prescribed by my physician. There had been no insurance flags, no pharmacist notes indicating concern. I closed my eyes briefly, not in relief, but in recalibration. Then she added something else. There had been an attempted pickup 3 days earlier. The system showed a request to release the prescription under my name. It had been denied because the individual could not present valid identification matching the file. The pharmacist logged it as a refused transaction. Karen read the date, Monday evening. The night Melissa had come by my apartment to check on me after Grandpa mentioned scheduling the review. The detail was not an accusation. It was a fact in a system. Karen explained that the pharmacy would not disclose the identity of the person who attempted pickup without a formal request from law enforcement, but the record of the attempt itself was part of the refill history. She had requested a written summary and expected it by email within the hour. The shift in my body was immediate and physical, not shock, alignment. There had been no overuse, no irregularity. Instead, there was a documented attempt by someone to obtain my medication without proper identification. Karen told me she would forward the summary to Grandpa once she received it and would recommend postponing any will amendments until the circumstances were clarified. She did not speculate beyond that. I thanked her and ended the call. For several minutes, I did nothing. I watched the late afternoon light move across the hardwood floor. I replayed Monday evening in concrete details. Melissa had arrived unannounced with takeout. She had set her purse on my kitchen counter. She had insisted on washing dishes while I sat down because my back was acting up. At some point, she had stepped into the hallway where I kept my bag. I had not counted my pills that night. The risk shifted shape. This was no longer only about how I appeared in a chair during a legal review. It was about someone attempting to access a controlled prescription under my name. I opened my email when Karen's message arrived. Attached was a PDF on pharmacy letterhead summarizing the past 12 months of refill dates and noting one refused pickup attempt on October 9th at 7:42 p.m. The notation specified, ID mismatch, release denied. The time mattered. That was during the hour Melissa had been in my apartment. I printed the document and placed it in a folder with my medical paperwork. I did not send it to anyone else yet. I wanted to see how it would be introduced to Grandpa first. Within an hour, Melissa texted me. She wrote that Karen had called her to confirm the pharmacy review was complete. She said she was glad everything was cleared up. She added that misunderstandings happen and that we should move forward as a family. She did not mention the refused pickup. That omission carried weight. I did not respond immediately. Instead, I called the pharmacy myself before closing time. I asked to speak with the pharmacist on duty and identified myself with the same details they had on file. I asked whether any medication had been released under my name without my physical presence or proper ID in the past month. The pharmacist confirmed that no medication had been dispensed improperly. She reiterated that a pickup attempt had been denied because the person could not present matching identification. She advised me to contact my prescribing physician if I believed my prescription had been compromised. Her tone was procedural, not alarmed. When I ended the call, the outline of the situation was clear enough to name. Someone had tried to obtain my medication and failed. That same week, my medication had gone missing from my purse. There was still no direct proof tying those events to Melissa, but the narrowing had begun. I emailed my physician's office and requested an appointment to document the missing pills and discuss whether an early refill would even be possible under state regulations. Illinois law did not treat loss-controlled substances casually. Any adjustment would require documentation. I was not ready to involve the police, not yet, but the stakes were no longer abstract. If someone attempted again and succeeded, it could trigger insurance scrutiny or pharmacy reporting that would attach to my name. That would not stay contained within a family conversation. As evening settled, I forwarded Karen's PDF to a new folder labeled Estate Review and added the date to a simple timeline document of my own. Monday visit. Monday attempted pickup. Thursday verification. Paper had begun to accumulate on my side as well. And for the first time since that morning in Grandpa's living room, the narrative was not floating on impressions. It was beginning to sit on record. My appointment with Dr. Patel's office was Friday morning at 9. They fit me in because I explained over the phone that a controlled prescription had gone missing and there had been an attempted pickup under my name. The receptionist did not sound surprised. She asked me to bring any documentation I had. The clinic was in a low brick building off Ogden Avenue, the kind of place with neutral carpeting and laminated privacy notices taped near the check-in desk. I signed in and handed over my insurance card like I had done dozens of times before. This time felt different. When the nurse took my vitals, she asked me to describe exactly what was missing. I told her the bottle had been nearly full on Monday morning. By Tuesday night, I realized several tablets were gone. I had not authorized anyone to retrieve medication on my behalf. I had not shared my identification. She typed without commentary. Dr. Patel entered a few minutes later, reading from his tablet. He had treated my spinal condition for 3 years. He knew my dosage history without looking. I gave him the printed pharmacy summary and pointed to the refused pickup entry. He reviewed it carefully. Then he asked whether I had reason to believe someone close to me might have attempted to access the prescription. The question was clinical, not personal. I told him only what I could state as fact. My sister had been in my apartment the evening of the attempted pickup. The medication was missing shortly after. I did not accuse her of taking it. I stated the sequence. Dr. Patel set the paper down and explained the implications plainly. Under Illinois regulations, lost or stolen, Schedule II medications require documentation. An early refill is not automatic. It can trigger pharmacy review or insurance scrutiny. If a pattern appears in the state prescription monitoring program, it can affect future prescribing decisions. He paused to let that settle. This was no longer about inheritance. It was about my long-term medical access. He said he could issue a partial replacement if I filed a police report documenting the suspected theft. Without a report number, he would have to wait until the next authorized refill date. That would leave me under-medicated for the next 3 weeks. 3 weeks was not a neutral number. It meant limited mobility. It meant missed workdays. It meant explaining to clients why deadlines slipped. I asked him to note in my chart that there had been a documented refused pickup attempt and that the bottle contents were inconsistent with the expected count. He agreed and dictated the entry while I sat there. Then he looked at me directly. If someone is attempting to access your prescription, you need a paper trail outside of this office. He did not advise confrontation. He advised documentation. I left the clinic with a printout summarizing the visit and a clear instruction file, a report if I wanted medication replaced legally. I sat in my car for several minutes before starting the engine. Filing a police report would formalize what had until now existed inside family walls and attorney emails. It would assign a category to the behavior: theft, attempted fraudulent pickup, misrepresentation. It would also mean that if Melissa had attempted to obtain the prescription, her name could become part of a police inquiry. I drove home instead of directly to the station. At my kitchen counter, I spread out the documents, the pharmacy summary, the clinic visit note, my own timeline. The pattern was no longer abstract. Monday visit, Monday attempted pickup, missing tablets, physician documentation, conditional refill pending police report. By mid-afternoon, Karen called again. She had shared the pharmacy summary with Grandpa. He had asked whether there was any explanation for the refused pickup. Karen told him the record did not include a name, only the mismatch. Melissa had responded by suggesting it could have been a clerical error, someone with a similar name, a misunderstanding at the counter. Karen did not challenge that interpretation directly. She told Grandpa she was waiting to see how I intended to proceed. That phrase settled heavily. How I intended to proceed. The choice had shifted to me. If I did nothing, the refused pickup would remain an anomaly, a footnote. If I filed a report, it would move into a different category of record. I looked at the clock. It was just after 3. The Naperville Police Department lobby would still be open for walk-in reports. I gathered the documents, placed them in a folder, and drove downtown. The lobby was quiet, fluorescent lit, with a counter separating visitors from the intake desk. A sign listed hours and instructions for non-emergency reports. I waited until the officer behind the desk looked up. I stated that I needed to file a report regarding a suspected theft of prescription medication and an attempted fraudulent pickup under my name. He handed me a form and asked for the basic details first. Date of suspected loss, type of medication, pharmacy location, any known suspects. My pen hovered for a moment at that last line. I wrote unknown at this time. The officer reviewed the form and told me an incident number would be generated once it was entered into the system. A detective might follow up if there was sufficient information to pursue. He did not promise action. He recorded the allegation. When he handed me the printed receipt with the incident number, something shifted permanently. This was no longer an internal family dispute. It was a documented allegation tied to my name and to whoever had attempted to access my medication. I texted Dr. Patel's office with the incident number as instructed and requested that the partial replacement be processed according to their policy. Then I drove home. By the time evening came, the decision had already begun to ripple outward. Melissa called twice. I did not answer. She left a voicemail saying I was escalating something that could have been handled privately. That word stayed with me. Privately. What she meant was without record, but the record now existed. And whatever happened next would not be erased by insisting it remain a family matter. The detective called on Monday afternoon. His name was Detective Aaron Wilkes. He identified himself as assigned to review my incident report regarding suspected prescription theft and attempted fraudulent pickup. His tone was direct procedural. He asked me to confirm the timeline again. Monday evening visit. Tuesday, discovery of missing tablets. Thursday, pharmacy verification. Friday, police report. I answered without elaboration. He told me he had contacted the pharmacy's corporate loss prevention office that morning. Because the medication was a controlled substance and there had been a documented refused transaction, they were willing to preserve any available in-store surveillance from that date. However, access to footage would require a formal request from law enforcement. The footage, he explained, might or might not clearly identify the individual at the counter. Cameras were positioned for security, not portrait detail. Still, it was a possible data point. He asked whether I wanted the investigation to proceed. The question was simple but consequential. Proceeding meant his office would formally request and review surveillance. It meant contacting the pharmacy manager and potentially speaking to employees. It meant that if someone I knew appeared in that footage, the matter would move beyond speculation. I said yes. He documented my consent and said he would issue a preservation request that day to ensure the footage was not overwritten. Many retail systems recycle data within 30 days. Time mattered again. He told me I might be asked to come in to review still images if something relevant was captured. He did not promise charges. He did not suggest an outcome. He described steps. When I ended the call, the situation felt less like a private crisis and more like a sequence unfolding through channels that did not depend on family approval. Melissa called that evening. This time I answered. She did not raise her voice. She asked why a detective had contacted the pharmacy. She said the manager had informed corporate that law enforcement had requested video related to my name. I told her I had filed a report and that the investigation was proceeding according to policy. She said I was turning a misunderstanding into something disproportionate. She said if the pharmacist had refused the pickup, then no harm had been done. The statement rested on a narrow definition of harm. I told her the issue was not only whether medication had been dispensed, it was whether someone had attempted to obtain it under my identity. She shifted tactics. She said Grandpa was unsettled by the idea of police involvement, that he was worried about family reputation, that Karen had suggested we resolve concerns internally before moving further. I did not argue about reputation. I asked one question instead. Had she attempted to pick up my prescription that Monday evening? There was a pause. She said she had gone to the pharmacy to check whether I was managing my medication responsibly. She said she did not intend to take anything. She only wanted confirmation. The admission was partial but clear. I asked whether she had presented her own identification. She said she had given my name and date of birth. She said the pharmacist refused because the ID did not match. That aligned with the record. She framed it as vigilance, as protective oversight, as something any responsible sister might do if she suspected overuse. The structure of her explanation mirrored the narrative she had introduced in Grandpa's living room, but this time there was a documented refused transaction and a police incident number attached to the sequence. I told her that attempting to access a controlled prescription without authorization was not a protective act. It was misrepresentation. I said the investigation would determine what, if anything, followed. She said she had not taken pills from my apartment. I did not accuse her directly of that. Instead, I told her that if medication had been removed without my consent, that fact would be included in the investigation. I said I had provided the detective with the timeline of her visit. Her breathing changed slightly over the line. She said I was forcing this into a legal frame. I answered that it was already there. When the call ended, I felt neither victorious nor shaken. The conversation had narrowed the field. Her admission of attempting pickup was now verbal, even if not yet in a written statement. The next morning, Detective Wilkes emailed to confirm that the pharmacy had secured the footage from October 9th and that he would review it within the week. He attached a formal notice indicating the investigation remained active. I forwarded the notice to Karen. Within an hour, she replied that Grandpa had been informed. She said he was concerned, but agreed that clarity was necessary before any executor decisions were finalized. She recommended postponing the will amendment meeting scheduled for Wednesday. That postponement had tangible impact. It meant no immediate changes to fiduciary roles, No signature-shifting authority while questions remained unresolved. Melissa sent a brief message later that day. She wrote that she had acted out of concern and that involving detectives was extreme. She asked me to withdraw the complaint. I did not respond. The system was moving now, not quickly, not dramatically, but in ways that generated records beyond memory. For the first time since that morning in the living room, I was not only defending myself against implication, I was participating in a process that required evidence to stand on its own. The outcome was still uncertain, but the field of doubt had narrowed to facts that could be reviewed frame by frame. By Wednesday morning, the investigation and the estate review were no longer separate tracks. Karen requested that Grandpa come into her office instead of rescheduling at his house. She explained in an email copied to both Melissa and me that given the emerging concerns, it was advisable to formalize the status of the will before any amendments were considered. Her office was in a 2-story brick building near the DuPage County Courthouse. The conference room felt neutral, in a way Grandpa's living room never had. No family photos, no familiar chairs, just a long table, filtered light, and framed certificates on the wall. Grandpa arrived with Melissa. I came separately. Karen began by summarizing the sequence as it stood, sticking strictly to documented facts. Pharmacy confirmation of compliant refill history, 1 refused pickup attempt under my name, an active police report, pending review of surveillance footage. No findings yet, but open inquiry. She then shifted to the estate implications. Under Illinois probate practice, she explained any credible concern about undue influence or misrepresentation affecting decision-making should be addressed before executing amendments. While no court action had been filed, she recommended documenting the current concerns in the estate file and postponing any structural changes until clarity was reached. Melissa objected to the framing. She said the police report was an overreaction. She said her visit to the pharmacy had been misunderstood and that she had already explained her intentions. She questioned whether the mere existence of an inquiry should stall Grandpa's plans. Karen did not debate intent. She returned to procedure. The issue was not whether Melissa meant harm. The issue was whether allegations involving identity misrepresentation and controlled substances created a conflict of interest regarding fiduciary responsibility. That term shifted the room. Fiduciary responsibility was not a family label. It was a legal standard. It referred to the duty of someone entrusted to manage assets in the best interest of another. Grandpa listened without interruption. For months, he had been considering naming Melissa as sole executor, consolidating authority in one place to simplify things. That was the language he had used earlier in the year. Now the simplicity looked different. Karen recommended a temporary hold on any amendment designating executor changes until the investigation concluded or until sufficient information clarified whether there had been misrepresentation that could affect trust. It was not an accusation. It was a risk assessment. Melissa shifted from defensiveness to offense. She suggested that my instability had been the original concern, and that now I was weaponizing process to block her from responsibility. She implied that involving police had created the very conflict Karen was citing. Grandpa turned toward me. He asked whether I had filed the report solely to prevent changes to the will. The question was steady, not hostile, direct. I told him the report had been filed because my physician required documentation to consider replacing medication, and because someone had attempted to obtain a controlled prescription under my identity. The timing with the estate review was not something I had orchestrated. It was a consequence of events that week. Karen confirmed that the clinic documentation and incident number predated any formal probate filing. She had copies in the file. That mattered. Grandpa folded his hands on the table and remained silent for several seconds. Then he made a decision that changed the structure of the room. He instructed Karen to enter a memorandum into the estate record noting the pending investigation and to suspend any executor modification until the matter was resolved. He also asked her to prepare an alternative structure in which a neutral, professional co-executor could be appointed if he later decided changes were necessary. Melissa's face tightened. This was not a removal, not yet, but it was a halt. The momentum she had built toward consolidated control had stopped. She argued that bringing in a professional fiduciary would incur unnecessary fees and complicate the estate. She emphasized family unity and privacy. Karen responded that professional oversight was standard in situations where intra-family disputes intersected with allegations of misconduct, especially when financial authority was at stake. The language stayed clinical. Grandpa concluded the meeting by stating that no one would hold unchecked authority while questions remained unanswered. It was not a verdict. It was a pause with consequences. After the meeting, Melissa did not speak to me in the hallway. She walked ahead of Grandpa to the parking lot, her steps measured but sharper than before. That afternoon, Karen emailed a formal memorandum for the file. It documented the current status: no amendment executed, executor designation, unchanged investigation pending alternative, co-executor structure under consideration. The memorandum created a timestamp. If future disputes arose, the record would show that concerns about identity misrepresentation and fiduciary risk had been formally acknowledged before any will revision. Later that evening, Melissa sent a longer message. She wrote that I was destabilizing Grandpa during a vulnerable time. She warned that extended investigations could strain him medically. She said I needed to consider the emotional cost. The appeal was not about legality now. It was about guilt. I did consider the cost, but I also considered what unchecked authority would cost if the pattern of control expanded beyond medication and into assets. The police investigation remained active. The estate remained unchanged. The possibility of a neutral executor now existed where it had not before. The pressure had shifted from questioning my reliability to questioning her eligibility for unilateral authority. It was not a reversal yet, but it was no longer a single narrative told from behind Grandpa's chair. Detective Wilkes asked me to come in on Friday morning. The pharmacy had provided still images extracted from the surveillance footage before releasing the full file to law enforcement. He said it would be easier to determine whether the person at the counter was someone I recognized if I saw them in person rather than through a forwarded description. The police station conference room was smaller than the public lobby. No dramatic lighting. Just a table, 2 chairs, and a desktop monitor angled toward me. He clicked through a series of time-stamped frames from October 9th at 7:42 p.m. The camera angle was from above and slightly behind the pharmacy counter. The woman in the frame wore a dark coat and had her hair pulled back. Her face was partially turned, but the profile was visible when she leaned forward to speak with the pharmacist. I did not need a second image. It was Melissa. Detective Wilkes did not react to my silence. He asked me to confirm whether I recognized the individual. I said yes. He asked how I knew her. I stated she was my sister. He documented the identification and told me that the next step would be to request the full video and obtain a formal statement from the pharmacist who handled the interaction. He explained that attempting to obtain a Schedule II medication under another person's identity could fall under attempted possession by misrepresentation, depending on intent and the specifics of what was said at the counter. He did not use dramatic language. He named the statute category and said it would be reviewed by the state's attorney's office once the investigation file was complete. The legal framing made the situation precise. It was no longer a question of misunderstanding. It was a question of whether her conduct met elements of a chargeable offense. When I left the station, I did not call Melissa. Instead, I forwarded Detective Wilkes's confirmation email to Karen with a short note stating that identification had been made and that the investigation was proceeding. Karen replied within an hour. She said that given the development, she recommended an immediate formal meeting to address fiduciary eligibility before Grandpa made any further estate decisions. She scheduled it for the following Monday afternoon in her office and requested that all parties attend. The phrasing was careful. Address fiduciary eligibility, not family disagreement, not reconciliation. Melissa texted later that evening. She said the detective had contacted her and requested that she come in for an interview. She said she had retained counsel and that her attorney advised her not to discuss the matter with me. The tone was different from previous messages, more contained, less accusatory. I responded only that communication regarding the investigation should go through counsel. Over the weekend, the situation did not escalate publicly. There were no dramatic confrontations. Instead, there was quiet reorganization. Karen sent a draft outline of potential estate structures to Grandpa, maintain current will unchanged, appoint a professional co-executor alongside a family member, or designate a corporate fiduciary entirely independent of us both. She copied neither Melissa nor me on that message. She told us about it separately, emphasizing that Grandpa would make the decision. On Monday afternoon, we reconvened in the same conference room near the courthouse. Karen opened by summarizing the updated facts. Surveillance footage confirmed that Melissa had attempted to obtain my prescription. A police investigation was active. Melissa had retained counsel. No formal charges had been filed yet. She then turned to Grandpa. She explained that fiduciary duty requires not only loyalty, but unimpeachable judgment in handling assets and personal information. Allegations involving identity misrepresentation and controlled substances, even before adjudication, created a risk profile that should be weighed carefully. Melissa's attorney was present beside her. He stated that his client acknowledged going to the pharmacy but denied criminal intent. He framed the action as misguided concern rather than fraud. He emphasized that no medication had been dispensed and that no financial loss had occurred. The language shifted the debate from emotion to elements. Karen responded that fiduciary appointment is discretionary. It does not require proof beyond a reasonable doubt. It requires trust that withstands scrutiny. Grandpa sat very still. He asked Melissa directly why she had not told him she went to the pharmacy when she first raised concerns about my medication. Melissa said she had not considered it relevant at the time. She said she believed she was protecting him from potential instability. The answer did not land the way it might have a week earlier. The room was not chaotic, it was contained. Grandpa did not announce a final decision that afternoon. Instead, he asked Karen to prepare formal amendment language reflecting the removal of any immediate executor change until the investigation concluded, and to draft an option naming a neutral professional as sole executor. He said he wanted to review both documents before signing. It was not a completed reversal, but the structure had shifted decisively. Melissa was no longer positioned as the inevitable authority over Grandpa's estate. Her eligibility was now under documented review with legal counsel present and investigative findings attached. As we left the building, she did not look at me. The confrontation had not been loud. It had been procedural. And for the first time since this began, the center of the question was no longer whether I could be trusted. It was whether she could. Karen sent the draft amendment the following Thursday. It arrived as a secure PDF with a cover note explaining that Grandpa had reviewed both proposed structures and was ready to formalize one of them. She scheduled a signing for the next Monday afternoon contingent on no new developments in the investigation. The amendment did two things. First, it removed any language naming Melissa as successor executor. Second, it appointed a licensed professional fiduciary based in DuPage County as sole executor with authority to administer the estate independently of any family member. It did not alter distribution percentages. It did not disinherit anyone. It shifted control. When I read the document, I noticed the precision. The language referenced the pending investigation only as background context for the decision. It did not accuse. It did not speculate. It stated that in light of recent events, Grandpa had determined that independent oversight would best preserve his intent, that framing mattered. Melissa's attorney responded within hours. He sent a formal letter to Karen arguing that the amendment was premature and that no charges had been filed. He stated that replacing a family executor with a professional would impose unnecessary costs and reflect an assumption of wrongdoing before adjudication. Karen replied with equal formality, "Executor designation," she wrote, "is not a criminal penalty. It is a discretionary appointment based on trust and risk tolerance. The absence of filed charges does not obligate a testator to maintain a prior fiduciary choice." The exchange remained on paper. Detective Wilkes called me later that afternoon. He informed me that he had completed his review of the full surveillance video and obtained a statement from the pharmacist. According to the pharmacist, Melissa had provided my name and date of birth and stated she was picking up medication on my behalf. When asked for identification, she presented her own driver's license. The pharmacist declined to release the medication due to the mismatch and documented the attempt. The detective said the case file had been forwarded to the DuPage County State's Attorney for charging consideration under attempted possession by misrepresentation. No decision had been made yet. The phrase charging consideration carried weight. It meant the matter had moved beyond preliminary inquiry. He also informed me that if charges were approved, Melissa would receive a summons rather than an arrest warrant given the non-violent nature of the alleged offense. That detail was practical, not dramatic. I forwarded the detective's update to Karen. On Monday, we met again in her office. This time, Melissa's attorney spoke first. He stated that his client intended to contest any executor change that implied misconduct and reserved the right to challenge the amendment in probate court if necessary. Karen responded that a testator's decision to appoint a professional fiduciary is presumptively valid, absent undue influence or incapacity. She asked Grandpa directly whether he understood the amendment and whether he was signing of his own free will. He answered clearly, yes. He said he had spent a lifetime building what he had and did not want family disputes to dictate its administration. He said that if trust had been strained, the solution was structure, not denial. Melissa did not interrupt him. The documents were placed in front of him. A notary public arranged by Karen's office verified his identity and witnessed his signature. The professional fiduciary's firm had already agreed in writing to accept the appointment upon his passing. When Grandpa signed, the shift was visible but contained. No raised voices, no dramatic declarations, just ink drying on a page that altered authority. Melissa's attorney requested copies and noted that they would review the amendment for potential challenge. Karen acknowledged the request and confirmed that the signed document would be retained in the estate file and that certified copies could be provided upon request. After the meeting, Melissa approached me in the hallway. She did not argue. She said that if charges were filed, it would affect her employment. She worked in compliance for a regional bank. Even an unresolved allegation involving identity misrepresentation could trigger internal review. The consequence was no longer theoretical. I told her I had not asked the state's attorney to file charges. I had provided facts to law enforcement because my medication had been compromised. She said I could still tell them I did not want to proceed. I told her that the decision no longer rested with me. As I walked to my car, I understood that the amendment did not resolve everything. The investigation remained active. The possibility of criminal charges remained open. Melissa retained counsel. Tension remained. But one axis had closed. She no longer stood behind Grandpa's chair with unilateral authority waiting to be formalized. The structure of the estate now rested in neutral hands. The confrontation had not been loud. It had been documented, notarized, and filed. The letter from the DuPage County State's Attorney arrived 3 weeks after Grandpa signed the amendment. It was not dramatic. It was a formal notice stating that after review of the investigative file, the office had approved a misdemeanor charge of attempted possession of a controlled substance by misrepresentation. Melissa was ordered to appear in circuit court on a specified date the following month. The language was procedural. Charge approved. Summons issued. Initial appearance scheduled. No commentary. Melissa's attorney informed Karen that his client intended to enter a plea of not guilty and pursue a negotiated resolution if possible. The case moved on to the public docket, where it could be tracked like any other. Grandpa read the notice at his kitchen table. He did not raise his voice. He folded the paper once and set it down. He said he was relieved the decision had not required him to guess. The probate file remained unchanged. The professional fiduciary's appointment stood. There was no challenge filed to the amendment within the statutory window. 2 months later, the criminal case concluded. Melissa accepted a deferred prosecution agreement. Under its terms, she admitted to sufficient facts to support the charge, completed a court-ordered ethics course, performed community service hours, and agreed to 1 year of supervision. If she complied fully, the charge would be eligible for dismissal at the end of that period. The court record reflected the agreement. There was no jail sentence, no spectacle. But the finding was real. Her employer initiated an internal compliance review once the charge appeared on the public docket. She was placed on administrative leave during the review. At its conclusion, she was reassigned to a non-supervisory role that did not involve access to sensitive customer identity data. Her title changed. Her compensation adjusted accordingly. The consequences were administrative, documented, and lasting. Grandpa did not reverse his amendment. He met once with the professional fiduciary to review how his assets would be administered and confirmed that distribution terms remained as he had always intended. He told me privately that structure had given him peace he did not realize he had lost. I refilled my prescription in person the next month. The pharmacist recognized my name and asked for identification. I handed over my driver's license and signed the electronic pad. The transaction was ordinary. That ordinariness felt earned. I did not resume regular contact with Melissa. We exchanged updates through attorneys during the supervision period when required. Beyond that, there was distance. I set one boundary clearly: any communication about Grandpa's affairs would go through Karen or the fiduciary. No informal requests, no side conversations. My parents adjusted slowly. They visited Grandpa separately at first. Over time, dinners resumed structured and shorter than before. No one pretended nothing had happened. The investigation closed at the end of the supervision term. The court docket reflected dismissal pursuant to completion of deferred prosecution. The public record showed both the charge and its resolution. Nothing was erased. It was completed. Grandpa reviewed his will one final time that winter. He did not change the beneficiaries. He did not restore family control over administration. He kept the professional executor in place and signed a brief letter of intent explaining that his choice was based on a desire for neutrality and clarity, not punishment. That letter became part of the estate file. The morning he signed it, I walked him to his car afterward. He moved more slowly than he had a year earlier, but his voice was steady. He said he had wanted his last decisions to reflect who he was, not who argued the loudest. I understood what he meant. The situation had begun with an accusation about my reliability. It ended with documented decisions about hers. I did not feel triumphant. I felt balanced. If you have ever had your credibility questioned in a room where someone else held the microphone, you know how quickly control can shift. The harder question is what you do when the room changes and you are finally heard. That answer for me was structure, and then silence.
This story is creative content developed for storytelling and reflection. It does not depict any specific real individuals or actual events.